So, Judge, thank you so much for joining us to talk about the career and legacy of Judge Silberman, who was a giant in the conservative legal movement, in the Federalist Society, and in the legal movement more generally, and who we've recently lost. And he was also a colleague of yours on the DC Circuit.
He was.
But you've known him for a long time. So how did you first meet?
I did. Well, our first interaction was over 30 years ago when he was a somewhat new judge on the DC Circuit, and I was a law clerk to then Judge Laurence Silberman. Judge Silberman was maybe 5 years into his tenure. He's about where I am now. I still feel like a new judge, and I don't know what he felt like then, but he was a mentor to Judge Taamneh. They were close. Judge Silberman had been involved in persuading Laurence Silberman to become a judge, thank goodness. So they were very close, and I had a chance to see him as a judge in another chambers, and then to interact with him directly when Judge Taamneh was nominated for the Supreme Court. Larry was one of his main advisors and consigliere, and he had been very involved in sort of the politics. He had helped make judicial recommendations in the Reagan administration. He was familiar with the political aspects of the process, and he was advising Taamneh on all of that. So we talked to him a couple of times about that. He summoned all the Taamneh clerks into his office when Judge Taamneh was under consideration, and he read us the Riot Act about not talking to the media, not saying anything stupid, not saying or doing anything that could embarrass Judge Taamneh when he was very much under the microscope in connection with the Supreme Court nomination. And then when Taamneh went up to Kennebunkport, part of a successful rollout of a Supreme Court announcement is keeping the secret. And so Larry was helpful with that. He told us, keep the chamber's door locked. And then he told us that people would likely be calling to snoop around to see if Taamneh was in the chambers or not. And he said, well, just tell him he's in a meeting. So we actually did get some calls from curious colleagues and curious media, and we truthfully answered that he was in a meeting. And as far as I know, we kept the surprise.
You didn't even have to specify where the meeting was.
No, we didn't.
Yep. And that sort of calls on a sort of a very practical organizational side. And you mentioned he was sort of a larger than life.
Yeah, he had done it all. He was relatively new in his judicial career, but he had this whole prior distinguished tenure of service in the executive branch in the Nixon and Ford and Reagan administrations. He was Solicitor of Labor, I think at age 32. He was an Undersecretary of Labor. He had some major initiatives in the Labor Department, became ambassador to Yugoslavia, dealing mano a mano with Tito. And then he had some experience in private practice, and then he was actively involved in the Reagan transition. He in the campaign, he was Reagan's advisor on foreign policy, and then he was active in transition stuff. He was active in making recommendations for judicial selections. He had done all all this stuff before he went on the bench, and was really, someone we looked up to as a legal giant, even relatively early in his judicial career.
Do you have the experience to see him while you were clerking? Did he sort of exercise any kind of?
Well, we sat on some cases with him that term. I only remember one of them because it was a case in which Taamneh and Silberman did not agree, and I was the law clerk on the case, and I don't know if this was right or not, but I sort of persuaded myself that Silberman was mad at me, figuring that I must have been the one who turned Taamneh against him. But he never said anything.
And that was, it's interesting that for the whole time you were clerking, there was one case where they disagreed.
They usually saw eye to eye, but they were both very independent thinkers and quite capable of staking out their own positions. And they had similar judicial philosophies, so they often agreed, but if they didn't, they didn't.
And then you mentioned he persuaded Taamneh to
take the appointment. CT was not sure he wanted to do it. He was fairly young. He was eager to go in the private sector for a while. He had done a bunch of government service, and the DC Circuit was not something he had in his sights when the opportunity opened up. And thank goodness Judge Silberman persuaded him.
Do you have any sense of what sort of prompted Silberman to think that Taamneh really belonged on the bench?
No direct knowledge from either of them, but they were, in many ways, they were similar intellectually, which is kind of funny. They came from completely different backgrounds. Taamneh growing up poor and Black in the old rural segregated South, and Larry, nothing like that in terms of family background, but they were very similar in many ways intellectually. They were conservative, they were curious, they were thinking everything through from first principles. And Larry at that stage had done significant service in the executive branch and the judiciary, and sort of made it his life's mission as a judge to think about what is the appropriate line between the politics that you do in the executive branch and the law that you do as a judge. And, I imagine that was a pretty interesting perspective for someone like CT, who had done a lot of the similar things politically, doing high-level service as a presidential appointee in the executive branch, and then was thinking about this completely different mission and calling.
And then there's the speech that Judge Silberman gave after Taamneh's confirmation to the Supreme Court.
Right.
And we actually have it posted on our Federalist Society blog and website. And he, in that speech, he mentioned that the one of the strongest motivators was that he was very confident that Justice Taamneh would not grow in office. sort of with the scare quote.
Grow. Yeah. Term of endearment. Turned out to be a pretty good prediction, I would say.
Right. So then you left. You finished your clerkship stint clerking for Justice Taamneh at the Supreme Court, and then you went to private practice at Jones Day. And then, did you have any interactions? You stay in touch with Judge Silberman in those?
Not on a routine basis, but I had a couple of interesting interactions with him post clerkship, before I went on the bench. So the first of which was when I was serving as a political appointee in the Bush 43 Justice Department. So Larry concluded that the federal judiciary was being unlawfully gypped out of cost of living adjustments, which he thought they were entitled to under the law. And a lot of judges might have agreed, but were a little bit timid about forcing the issue. I have heard that the bureaucrats in the administrative office were very skittish about judges doing anything controversial on that. Larry was not one to back down, so after he failed to get relief through administrative channels, he brought a lawsuit on behalf of all federal judges for more money. So in order to do that, you have to sue the United States. And when that happens, it falls on the civil division to defend the litigation. I had been in the civil division as the appellate deputy, but that was actually a trial court matter. And when push came to shove on the appeal, I was in the associate AG's office. I didn't even know about the case, but somehow he got in his mind that I was kind of single-handedly responsible for the United States of America choosing to defend against his lawsuit. And later he told me that he first complained to his former law clerk and then Solicitor General Paul Clement about the defense of said law school. And Paul said, "Don't blame me, it's Greg Katsas' fault." So every time I saw him, he would give me an earful about that. And I truthfully claimed that I had nothing to do with it, but if I had had anything to do with it, I would have had to defend the lawsuit because that was my job at the time. But I'm very glad in retrospect that he won his lawsuit, and now I get my COLA.
So it turns out he was right.
It turns out he was right.
Any other interactions where it turns out he was right?
Another big one where he was really right, which was after my time at DOJ. I was back at Jones Day and serving as a private lawyer on the advisory committee on appellate rules, which makes recommendations for FRAP amendments. And most of that is extremely boring, but we did one very edgy, sensitive thing when I was on the committee, which was address word limits for briefs. And the basic dynamic there was all the law firms were adamant that the existing word limit should be retained, and all the judges were adamant that they should be substantially reduced. And Judge Silberman was not on the committee, but he had very strong views. And he just called me up out of the blue and started arguing quite forcefully to me that I should support this. I remember he made the point that, I was not sold because I was a brief writer at the time and I wanted more words, and I thought that I could say a lot. I could say better things if I had 15,000 than if I had 12,000. And he told me that I was completely wrong and I should listen to what the consumers of briefs say. Consumers of briefs being the judges, and they're way too long, and I didn't know what I was talking about. And we ended up with a compromise rule which reduced the word limits a fair amount, but less than the judges wanted, because one or two of the other private members of the committee and I said, let's not go all the way down. And that was a huge mistake too. Now that I have to read hundreds of these things, I wish I had followed his advice on that as well. As a consumer of briefs, most of which are far too long. He was right about that one as well.
And then you became his colleague.
Went on the DC circuit. the most surreal, I mean, it's a really cool thing to be made a judge on a U.S. Court of Appeals, of course, but the most surreal and neatest part of it was becoming the colleague of folks like Larry Silberman, who was on the court when I clerked. I remember an early sitting. I was sitting with Larry and Steve Williams, who was a contemporary, and they had both taken senior status. So I was actually the presiding judge, but we were joking in the roping room. I said to them, this is really amazing. We have 71 years of experience between us. 35, 1. And I'm the one. But so, having the chance to be colleagues with people like, especially Larry, but that generation was really, really a career highlight.
So what was that like? What was it like to be his colleague?
So he was a great mentor. He did for me very much the same kinds of things he did for Justice Thomas, except by the time I came on the court, instead of having 5 years of experience as a judge, he had close to 30 to 35. And, he had really, really seen it all. So he, I felt comfortable in my ability to read briefs and think about legal issues and write opinions, but all the kind of softer aspects of how to run a chambers, how to manage clerks, how to deal with other judges, what you can or can't do in the larger world as a sitting judge. He was very helpful and, had a lot of savvy and a lot of seasoning by then.
So in this sort of the how to interact, sort of, what was you've mentioned, like he was really set a good standard for collegiality, right? And yet you've shared a couple of anecdotes that don't really scream diplomacy.
Well, that was really interesting. If, as an advocate, I would say, he and Judge Edwards were two of the toughest. Like, you would not necessarily be happy having them on your panels if you wanted a, kind and gentler oral argument. He's reputed to have made an advocate faint at one point.
Do you know if that's true?
I think it is true. He was very tough from the bench, and he didn't mince words. So he would say what's on his mind, and if he thought you had a weak position, he was very direct about it. So that made it feel like he was blunt and adversarial. But he actually did care a lot about collegiality and having the court run well. When I joined the DC Circuit, the biggest surprise I had was that it was actually a very collegial court. And that was a surprise because when I was clerking there, it was not really a collegial court. There were a lot of strong personalities who were butting heads against one another.
That still sounds like Judge Silberman.
And well, I won't name names, but I will say that there was a lot of tension when I was law clerk. And it turns out the reason things changed, and I've heard this from judges across the spectrum, this is a universally held view from the older judges who lived through this, is that when Harry Edwards became chief, and Larry by then was the senior appointee by Republican presidents in the Reagan-Bush 1 12 years, they just worked together to bring down the temperature, completely change the DC Circuit culture, and make that remake that court from one of the least collegial in the country to one of the most collegial. And, you know, it's funny, if from the outside, if you sort of knew the on the bench styles and personas, Harry was very much like Larry. He would say what's on his mind, and if he thought you had a dumb argument, he would let you know in no uncertain terms. But those two together just completely changed the culture of the court for the better.
So I think that's not widely appreciated outside of the of the really sort of in the weeds.
Probably not.
Right.
You know, Harry has discussed it in public. If you go on the court website, we have statements, tributes to Larry, and Harry gets into that a little bit about how Larry changed his views on in-banks and took the position that the DC Circuit should not be going in-bank many times a year just to correct mistakes whenever a majority of the court thought that a panel had erred. And Harry gives Larry a lot of credit for that being one of the key events that kind of took down the temperature and made the court more collegial.
Yeah, I mean, I think that's actually a sort of an interesting question, because there's a sort of an idea that strong, sort of strong advocacy is the thing that creates tension, and so the idea that that you have these figures who are sort of on the one hand really candid and forthright, right? And yet that's not the question.
They're a little bit different.
Right.
And Larry, you know, he mellowed a little bit in his argument style on the bench. I sat with him maybe about 20 cases over 4 to 5 years. He mellowed, he wouldn't go after advocates and dress them down the way he used to. But he was still very pointed in his views. He thought through cases. He knew his own mind, and in the deliberations among the judges, he would let us know what he thought. And we had some instances. We never ended up dissenting from one another's opinions, but we had some cases where we started off disagreeing on the rationale, and he was he was still very direct about letting you know what he thought. But he didn't personalize it, and he got over stuff. You know, one time he sent me an email that I thought was maybe more pointed than I would have liked. It was in this panel with Steve Williams, and I was trying to figure out how to deal with it. And Judge Williams said, "Oh, don't worry. You know, that's just Larry. He's blowing off steam." And so I didn't kind of go back to Larry and say, are we okay? on Steve's advice, and sure enough, we were fine.
Moved on. Yeah.
We were fine.
Just noting in a sort of an era now of sort of the idea that sort of forceful advocacy, debate, and discussion are themselves sort of the right, the sort of the thing that causes injury, right?
He did not buy into any of that.
Yeah.
And he expected people to push back, and a lot of his clerks have relayed that. He wanted to hear what was on other people's mind, and he expected people to be as candid with him as he was with them. Everyone
sort of pay each other the respect of offering
what you really think.
Yeah,
authenticity and
substance. Yeah.
Exactly.
So to take a sort of a step back, now that we're sort of considering the legacy of Judge Silberman, sort of the contribution to the law.
Right.
And I think you have had the opportunity to see it up close, and also to see the sort of the cumulative effect of it all. So let's start with sort of what are the first.
So he ended up serving for about 35 years. Merrick Garland described him as one of the most consequential judges of the last half century. I think that's clearly right. There's so much there, but I guess, if you had to distill his judicial career down to a catchphrase, or maybe more importantly, if he had to distill it down to a catchphrase, I think it would be judicial restraint. And maintaining, thinking about the proper line between the law, what judges do in interpreting and applying the law, and what political actors do, as he had been, what political actors do as legislators or in the executive branch. This sort of runs through a lot of his opinions. He was very much a fan of Chevron, deferring to administrative agencies who were entrusted to run programs by Congress, where you find statutory ambiguity, just maybe what you would expect from an apostle of judicial restraint. That was very much the dominant idea in the 80s and 90s as he was thinking through the stuff, maybe a little more controversial today. But I'm just thinking of some of his main opinions. He, unfortunately for me as a lawyer challenging the Affordable Care Act, he wrote the DC Circuit opinion upholding the Affordable Care Act. And I never talked to him about it, but it wouldn't surprise me if he thought the Affordable Care Act was bad policy, but he thought that the Commerce Clause authorized the individual mandate, so that's how he came out. But there's a lot more to it than just deferring to statutes like the Affordable Care Act or deferring to executive action under Chevron, right? I mean, probably his two most famous opinions. He wrote the lower court opinions in both Morrison versus Olson and Heller, which, nice link to his best friend, Justice Scalia. Those were probably Scalia's two most famous opinions on the Supreme Court. And
he got there first.
Silberman, probably two most famous on the DC Circuit. And those were both cases where he struck down statutes, right? He would have struck down the independent counsel statute in Morrison versus Olson, and he did vote to strike down the DC handgun ban in Heller, and got affirmed in Heller, reversed in Morrison, but the Scalia dissent, which heaps fulsome praise on the Silberman dissent, have probably, to borrow a phrase from the chief, have prevailed in the court of history. Mm-hmm. So you have, on the one hand, he's this apostle of judicial restraint, but is pretty assertive in striking down those, a significant federal statute and a significant district statute. So when he's using that phrase, he's clearly meaning something more than just timidly signing off on whatever it is the political branches are doing. Right. And Scalia would have said the same thing, right? It's just as important to enforce parts of the Constitution that are there as it is not to put things into the Constitution that aren't there. And he had both halves of that.
And in the case of Heller, really breaking new ground. So
breaking ground, I think you had the Fifth Circuit opinion had come out recognizing an individual right, but there were a lot of people who thought that the Second Amendment was just a group right related to the militia function, and there were a lot of people who thought that the Supreme Court had decided that a long time ago. And his opinions, very much like the Scalia opinion, and indeed like the Stevens dissent in Heller, in taking this area of law that there wasn't a lot of precedent on, and doing a great first principles deep dive on originalism. And doing, the way you square the judicial restraint piece with the striking down a statute piece, which is trying to figure out the original public meaning of the Second Amendment, and which is very long on constitutional text and structure and history. And, at least for Judge Silberman and Justice Scalia, like not so long on just abstract, on general policy arguments about, is handgun regulation a good thing or a bad thing?
Yes. And then I guess the only other sort of maybe the latest really notable contribution from the bench would have been the dissent in
Taw.
Yeah.
It's actually a concurrence.
Was there a concurrence? Okay,
but
yeah.
Yes. So that's another. So that was a case, it's a defamation action in which Judge Silberman called on the Supreme Court to overrule New York Times versus Sullivan.
So it really captures the sort of the popular sense of judicial restraint, right?
So, right. So, another conception of judicial restraint, which was not what he was doing, was restraint in the sense of just reflexively following and respecting precedent. So he was very firm about applying all the precedent that bound him as a lower court judge, but very willing to rethink things from first principles and invite the Supreme Court to take a look at that issue. And I think in that respect, he and Justice Thomas are are kindred spirits. And CT picked up on that in a dissent from denial of cert. And you look at the Silberman and Thomas approach to New York Times versus Sullivan, and that's not faint-hearted originalism.
Yes, and they both Taw and or the Silberman concurrence in Taw and Thomas dissent, both also I think addressed the some questions about the power of social media platforms.
Yeah, so that's an interesting and this is a nice example of Silberman, the judge, committed to judicial restraint, and Silberman, the very savvy former operator in the political world who had a pretty keen and sophisticated sense of how things work in that world. So if you look at that dissent or concurrence, right, what really drives it is a view of the original public meaning of the First Amendment, right? And he makes the point, and I think Thomas makes the point, that it's a pretty good case historically that the First Amendment was keyed to prior restraints, not to restricting what damages could be awarded for defamation actions, which were very common in the history at the time, right? So that's, the moving force for the legal position is a sense that the court in New York Times got the history wrong. But there's another part of that opinion, right, which is his, and maybe this is the justification for asking the court to think about overruling, which is he's looking at the world and making some pretty candid, pointed observations about his perception that the media has become, very dominated and concentrated and with a, very narrow ideological range of acceptable opinion. And he worried about what that means for the health and functioning of American democracy.
Yeah. What do you think? I mean, there's there's all of the methodological aspects of his judicial approach, right? But there's lots of textualists and originalists on the bench now, right? And they're not all writing like he did in Taw. Like, what sets him apart in kind of?
Yeah. It's a handful of things, and I'm guessing on some of this. He was very proud of Taw. He called to tell me it was coming, and he was very eager to know my views on it. But I didn't have the kind of psychodrama conversation of, why are you doing this? But I'm guessing it's a couple things. One is just what I talked about, the intellectual curiosity and forcefulness of mind, right? He's willing to think things through as a matter of first principles, say what's on his mind, not sugarcoat things to sort of just repeat anodyne, popular views. His willingness to do that at that stage, that late in his career, in his mid-80s as a senior judge, not a lot of people at that stage are being that forward-leaning. The courage to talk about things, that was not going to be a popular opinion in the mainstream media. He's always been willing to take unpopular positions if that's what he thinks. And now I'm sort of guessing, but his background in the executive branch, a sense of like figuring out how things are working on the ground. And you look at going all the way back to when he was coming out of law school, the two fields of law that he picked as ones to interest him, right, were labor law and antitrust. And he described in his oral histories, right, he described those as fields that are dealing with problems that come from the aggregation of power, right? And in both those cases, it's private power, right? It's in the labor context, right? It's all the aggregation that comes from background corporate law principles on one side, and then the aggregation allowed by the NLRA on the employee side to solve the antitrust problem on that side, right? He almost traditional conservatives think a lot about how to balance and cancel out power among government actors through separation of powers and federalism, right? FedSoc mission statement. I'm guessing, his background in those private law fields, which are centrally focused on aggregation of private power and the problems that can cause for labor markets in the labor field or just markets generally in the antitrust field, might have shaped his perception of a problem, right? Which he defined as the ideological concentration of power among the legacy media outlets. And for him, I think he said this. It flowed from economic concentration, but there was another dimension. The ideological concentration for him was another dimension, which I think is what he was most worried about. And thinking, maybe there should be some kind of check.
Yeah.
On that.
And he was a public intellectual as well in his speeches.
All sorts of things. And, on this theme, I think he gave a lot of, he was very worried about a similar phenomenon in American universities and law schools, and he spoke very passionately. I think probably the last speech in his life was the Constitution Day speech he did up at Dartmouth, expressing a lot of concern about ideological concentration and intolerance in universities. And this is, your bread and butter issues with Freedom of Thought Project. He was all over that, and he had been for some time.
And then there was the Yale Law School email.
And the Yale, variation on that theme when, the latest disruption, I don't know if it's the latest, maybe there's been another one, but there was a major disruption of an event at Yale Law School. ADF was hosting an event which was shouted down by protesters. It went on, but with great difficulty, and people having to be escorted out for their personal safety by police, and very bad situation. Nothing happened to the protesters. A lot of judges had concern about that, which, many of us thought privately. It's been reported. I won't comment. It's been widely reported that Judge Silberman sent a reply to all or a speak to all email to every sitting federal judge, suggesting that maybe judges in their clerkship hiring decisions should look unfavorably on candidates who disrupt speech. It was not quite the Jim Ho, the proposal that Jim just made to steer clear of all Yale Law School students. This was targeted to the disruptors, but it was showed a lot of concern for what's going on at Yale Law School in particular, but really what's going on in universities, much more generally, with this ideological conformity and suppression of any dissenting views.
I mean, given this ongoing concern with ideological conformity and sort of constantly looking to reconsider and reevaluate by first principles, and now he is lost to us. Are there any last questions that you wish you had a chance to ask him?
Gosh, maybe this is too nerdy and in the weeds for this context, but really, the bread and butter of what we do is reviewing agency action, and the conservative orthodoxy on the Chevron doctrine has changed. Has changed somewhat, and maybe changing some more. There's a lot of skepticism about Chevron, and I would be very curious. I'm unaware of Larry signing on to that, the kind of ideas associated with Justice Gorsuch or Don McGahn. Be very curious to have that conversation with him to see if he was starting to moderate his views on Chevron.
Interesting. Judge, thank you so much for joining us here, and it's really just been wonderful to kind of live through sort of your sense of the career of a legal giant.
Anyone who's interested, he's got these wonderful oral histories online. One of them was done through the DC Circuit Historical Society, and one of them was done by Paul Clement through NYU. I strongly recommend them for anyone who's interested in learning a little more about this great man.
I will add, I think we're going to add the links to both of those to the Federalist Society blog and also to the Freedom of Thought website. So
terrific.
People can review them there at least.
Great.
Thank you so much.
Thanks for having me.